Hola, hola, buenos días. Soy la abogada Brittany James y estoy aquí para contestar todas sus preguntas de inmigración aquí en vivo. Si tiene algunas preguntas de inmigración, puede poner sus preguntas en los comentarios y puedo contestar más preguntas que puedo. Recuerda que en esta situación solamente puedo contestar preguntas en generales. Si quieres una respuesta o una opinión legal sobre su situación específica, debe llamarnos para programar una consulta. Nuestro número de teléfono es 772-539-8400, pero puedo contestar cualquier pregunta en general que tiene para dar más información sobre inmigración y explicar un poquito de cómo las cosas funcionan. Pero si quiere una consulta sobre su situación o una opinión legal, debe llamarme para programar una consulta privada conmigo donde realmente podemos estudiar toda su situación, toda su vida y ver cuáles opciones tiene por inmigración. Hi, Shalene, how are you? Y puede poner sus preguntas aquí en español. And also, if you have any questions in English, you can also write your immigration questions in English, and I will try to answer as many of them as I can. As I was explaining in Spanish, I can answer general immigration questions. If you want a legal opinion about your case specifically, then you should call my office to schedule a consultation so that we can talk about all the details of your situation and see what options you have. And again, my phone number, you should see it on the screen. It's 772-539-8400. Hi, Mary. How are you? All right. Well, while I'm waiting for some questions, I'm going to explain a few things that are really important that I've been wanting to talk about. I've been talking a lot first about DACA. This was a huge deal that a federal judge said that immigration has to start accepting new DACA applications. So if you do qualify for DACA and you have never applied before, you should consult with an attorney and consider applying for DACA. DACA is a great benefit. You get a work permit for 2 years that you can renew every 2 years, as well as protection from deportation. And just to review the requirements briefly, you have to show that you entered the United States prior to June 15, 2007, that at the time of your entry that you were under 16 years of age, that on June 15th, 2012, that you were under 31. You also have to show that you either graduated from school here or that you are currently in school. And for that requirement to show that you're currently in school, it could be a program to study to take your GED exam. It could also be an adult education program to study English to prepare to take your GED, or just a basic adult education English class. There are also certain criminal restrictions if you've had a DUI, if you've had a felony. There's some other charges that can disqualify you. The typical driving without a license charges do not disqualify someone from applying for DACA. And so if that's the only problem that you've had before, then that would not be an issue. But any other criminal issues, you should definitely consult with an attorney first and make sure that it's not going to be a problem in your situation. And I'm going to explain this also briefly in Spanish. And if you have any questions, you can go ahead and write your questions in, and I will try to answer them when I'm done explaining this. So, quiero explicar también en español un poquito sobre el programa de DACA. Eso eran muy buenas noticias, que este juez dijo que migración tiene que aceptar nuevas aplicaciones ahorita. So, para calificar por DACA, tiene que probar que en la fecha, el 15 de junio de 2012, que tenían menos de 31 años. También tiene que probar que entró al país antes del 15 de junio de 2007 y que cuando entró al país, que tenía menos de 16 años. También tiene que probar que estuve aquí desde el 15 de junio de 2007 y que graduado de escuela o que ahorita está en un programa de escuela, y la escuela puede también ser un programa para estudiar inglés. Eso califica también. También hay ciertos crímenes que pueden causar problemas con la aplicación. So, si tienen una convicción por algo, debe consultar con un abogado para ver si califica por DACA o no. Ok, estoy recibiendo unas preguntas aquí. So, estoy en vivo ahorita en Facebook, TikTok y Instagram. So a veces estoy recibiendo preguntas en los tres lados, ¿ok? So si no veo las preguntas, quizás es porque está en otra aplicación. Ok, Fatima, si te pregunta qué tipo de pruebas puedo usar para DACA, para probar que yo estuve aquí en los Estados Unidos. So, cualquier documento que tiene su nombre y la fecha y que es un documento de los Estados Unidos. También puede ser cualquier documento que tiene su dirección, como una carta que fue mandado a su casa, biles, talones de cheque, cuenta de banco, también prueba que estuve en la escuela aquí, prueba que fue el doctor, al dentista. So, hay muchas diferentes pruebas, pero realmente cualquier documento con tu nombre y la fecha y un documento que es algo de aquí, ¿sí? Ok. All right, Lorena Arlene. My mom tried to fix her papers through my brother, but she couldn't do it. Would I be able to help her? So I would need to know more information about her situation to see if you would be able to help her or no, or not, and also to understand why your brother could not help her. There could be various reasons why they said that he couldn't help her, but I would really need to have a consultation with her. So in general, a child who is over 21, who's a U.S. citizen, can file a petition for their parents. As far as whether that petition can convert to residency or not, there are many factors that we have to look at, such as whether the person entered the United States legally or not, whether they had a petition prior to April 30th, 2001, whether they have had various entries to the United States or only one. We have to look at criminal record, any issues with misrepresentation or claims to citizenship. All of those things can affect whether that petition from your brother could actually convert to residency or not. Sometimes there are other options where we may be able to help someone in a different way, but I would need to have a consultation with her to see what options she has. So if you or your mom want to call us at 772-539-8400, we can schedule a consultation and I can review her whole situation and see first, why was she told that your brother could not help her? Is there a way that he could, or is there a way that you could help her? Or also is there a way that she could actually file on her own? A lot of people wait for their children to turn 21, thinking that once their child is 21, that is the key to getting their residency here. And many times by doing that, they are not realizing that they actually have an option already. Sometimes they don't, but many times I have seen that people do already have options, or they don't realize that it's not as easy as they think when their child turns 21. So I do recommend that anyone who does not have status schedule a consultation with an attorney, really review your whole situation and see what options you have, and then you can come up with a plan. If that plan is waiting for your child to be 21, then that's okay, but sometimes there's another option before that, and there's no reason to be waiting and risking having issues with immigration. All right, let me see. All right, Blerta, hi, how many days after the green card interview notice is the actual interview? This really depends on the local office and also on who is scheduling the interview, whether the interview is actually being scheduled by the local office themselves or if the interview is being scheduled by the service center. I will say in general, we usually have about a month's notice. I've seen sometimes where there's only a week's notice. So it really just varies case by case, but usually it's around a month. All right, and I have another question here. Abogada, entonces las pruebas deben ser desde el 2007 en adelante. Sí, pero si tiene que probar que estuve aquí por DACA desde el 15 de junio de 2007 hasta ahorita. Pero también tiene que probar que entró al país antes de tener los 16 años. So, si en 2007, si tenía menos de 16, sí, puede tener las pruebas desde antes de junio de 2007 hasta ahorita. Pero si usted cumplió 16, por ejemplo, en el año 2005 y vino aquí en 2003 o 2004, va a necesitar la prueba de esta fecha porque tiene que probar que estuve aquí antes de los 16 años. Y eso son dos cosas separadas. Por ejemplo, si entró al país en 2003 y tenía 15 años, debe tener prueba que estuve aquí en 2003 y también tener la prueba de 2007 hasta ahorita. Ok, eso sí depende en su caso, pero siempre sí necesita la prueba desde junio de 2007 hasta ahorita. Okay, and you're welcome, Lerta. All right, Manpreet, how long will it take for my husband to come to the USA if I have a green card? So this depends on a lot of things, but first of all, on what country your husband is from. Because each embassy has their own processing times. As far as a resident applying for their spouse, I'm going to just double check the visa bulletin here, but I believe that it is current still for all countries, yes. So for all countries, for spouses of residents, the category is current, which the significance of that means that once you have to file a petition first. Once that petition is approved, then some people have to wait for a priority date to be available based on the date that they filed their application. But right now, for spouses of residents, the category is current. So that means that there would be no wait after that. But the wait would be based on how long it takes for the petition to be approved, which depends on USCIS. It could take a year, it could take a year and a half. It really depends on the USCIS processing times, and I've seen some cases are also approved faster than others. And then after that, there's a process that has to be done through the National Visa Center, where they are basically preparing the case for the interview in the home country. And then once they can confirm that they have everything that they need for the interview, then they will put your husband in line to get an interview appointment. And as far as how long that line takes, how long it takes before he gets scheduled, it really varies and it depends on the embassy. I will say even pre-COVID, for example, for the embassy in Ciudad Juarez, it was taking about 13 months from the time that everything was ready before they actually scheduled the interview. Now, I presume for Ciudad Juarez, it will probably take much longer because the embassies have been closed for several months. But that would just really depend on the processing time for the country where your husband is from. All right, Dulce Jimenez, do you know if the Juarez consulate is open now and is taking appointments? So they are scheduling appointments, but they are first scheduling all of the appointments that were canceled due to COVID. I can say that I had, I believe I had 2 or 3 appointments that were scheduled at the time that the embassy closed and they had to be canceled. I have seen one of those appointments get rescheduled, so I'm still waiting for the others. But that is what I've heard, is that they're going to be first scheduling those appointments that were canceled, and then they will continue on from there, focusing first on spouses of U.S. citizens and minor children, so on immediate relatives, and then they will go on from there. So I'm not really sure, depending on where you are in the process, it could still be a while. If your appointment was canceled due to COVID, then you should be hearing from them within the next couple months, I would presume. All right, and another question here is regarding DACA. What if I don't have enough evidence from 2009, but other years I do? So this is going to depend on the officer that has your case. Of course, you had to have been here in 2009, but as long as you were here in 2009 and it was just an issue of you don't have a lot of proof for that year for one reason or the other, you can show what proof you have. You can also use letters from people that you know, such as an employer or a church or friends, stating that they know that you were here during that time. Now, letters cannot be used for proof that you were here prior to age 16, but letters can be used for filling in some gaps in evidence. But as far as exactly how much evidence they have to have, it's really hard to say. We usually aim to have one document for every month if we can, and that has always worked for us. but that doesn't mean that they definitely would not approve it if you only have a few documents for the year. It's just really going to be up to the officer that has the case. But I would recommend that you consult with an attorney and review the evidence that you have, and that way they can tell you if, based on their experience, if they think that that should go through or not. So I'd be happy to take a look if you want to call and schedule an appointment, and you can send in all your documents, and we can go over it together, and I can give you my opinion on what I think about your chances. And again, our phone number is 772-539-8400. All right, Alicia says, my husband has his green card interview January 11th. How long does it take for his card to arrive? So I don't know, based on this question, if you're referring to an interview inside the United States or outside of the US. If you're referring to an adjustment of status interview inside of the United States, they generally will tell you that you should expect the card within 2 to 4 weeks after the interview. But I will say in most cases, I have seen it coming faster than that. I've usually seen about a week or so. And I can tell you, I had an interview, I believe it was one day last week. It's last Wednesday for a client here locally for an adjustment of status interview. And they just emailed me today with a picture of their card that they already got it in the mail only a week later. And I would say that's usually what I've been seeing, is about a week or so after the interview. And that's if it's an appointment here for adjustment of status within the United States. Now, if his interview was outside of the United States and then you're having to pay the immigrant visa fee for the card, that process is a little bit different and it can take a few months. But if it's inside the United States, then it's usually pretty quickly. All right, Jessica Chavez, I have the DACA card. Is there any other way for me to become a resident without getting married? I would need to know a lot more information, Jessica, to see if there's something that we can do to help you. And so some of the things that I would want to know is, for example, when did you get DACA? How old were you, to see whether you accrued any unlawful presence or not? Any other details about your entries, whether you only entered once or whether you came in and out at all, even as a child, whether you have an employer that's willing to sponsor you, whether your parents have status. You know, we would also go over any previous employment history to see if you were ever a victim of trafficking. I would need to know a lot more. Sometimes there are options without getting married. But we would need to have a personalized consultation where I can ask you all of these questions and review your situation and see if we can find an option for you. All right, let me see, whatever. Okay, and Alicia, I see your answer now that it's inside the US. So yes, it should be very quick after the interview. As long as everything goes well and they actually approve it there on the spot, then usually within a week. It could be a little bit longer, but I would plan for, you know, within a week or two. I will say that depending on the officer that has his case, some of the officers will approve it right away. Other officers need more time later on to review the case before they officially approve it. So that could also depend on the officer that gets the case. Okay. Okay, let me see. Y recuerda también, si tiene preguntas, puede poner sus preguntas en inglés o en español, en cualquiera de los dos. Okay, I have a question here from Anna Lydia in Facebook. It says, my dad is a U.S. citizen, my mom is a resident, and I have DACA. What are my chances to get approved if I apply for residency or citizenship by dad? So, and I would need to know a lot more information from you, such as was your dad a U.S. citizen by birth, or did he naturalize later on? Was he on your birth certificate? Did he actually recognize you as his child? If that's not the case, that if he became a U.S. citizen later on and was not a citizen by birth, then he would not have been able to pass citizenship on to you. So then you would be looking at how could you apply for your residency. And I would need to know, again, a lot more information to see what your options are. If you're an adult over 21, well, then also depending on which country you're from, it could sometimes take a very long time to get your residency through a parent once you're already an adult. So I would need to know those things too, your age, and if you scheduled a consultation, then we go over your full history and really see what options we can find for you. But just with this information, unfortunately, it's too hard for me to, it's really impossible for me to tell you what your chances are. I would need to know a lot more information, which is why I know a lot of people don't understand this. Sometimes they try to send me a brief question by message, wanting to know, can they apply? And I always encourage everyone to schedule a consultation because, like I said, also I can give some general information in these types of settings live, and it gives everyone a little bit more of an idea of how things work with immigration. But to really give you a personalized legal opinion about your case, we need to spend a lot more time together than just a quick question on Facebook Live or TikTok Live. So I would definitely suggest that you schedule a consultation. We can go through a full screening. Usually our screening process between a screening with my paralegal and then with me usually lasts about 2 to 3 hours overall between 2 appointments. So we are very thorough to really make sure that we look for every single possible option for you. So I would suggest, Anna, that you call us and schedule a consultation and we can see what options you have. Okay, Mariano Zapera, I just got my permanent resident card. I've been married for 3 years. When can I apply for citizenship and what forms do I need to apply? So in general, all right, if you are a legal permanent resident and you have been married to a U.S. citizen for 3 years, as long as you meet all the other requirements as far as residency, you haven't traveled outside the U.S. for more than 6 months, you don't have any criminal issues, and you meet all the qualifications, then you can apply for U.S. citizenship after 3 years of having your residency. And that's if you're married to a U.S. citizen. Technically, you can actually file at 2 years and 9 months. So you can file 3 months prior to actually qualifying. But if you are not married to a U.S. citizen, then you would have to wait until 5 years to qualify. And technically, you could actually file at 4 years and 9 months. Okay. All right. Hi, Alex Rodriguez. How are you? All right. And I have another question here. Is Tuesday the last day to turn in the Daca application? I have not seen anything about any deadlines of turning in Daca applications. And if if they've announced something new that I haven't heard, then please send it to me. And I would be very upset about that. But what the court ordered was that USCIS has to accept new Daca applications. Of course, whether DHS is going to do something to try to stop that, I don't know. So far, they haven't. So far, they have made a formal announcement on the USCIS website that they are accepting new applications, and we have been sending new applications. And we will continue sending new applications until we are no longer allowed to. So I have not heard anything about a deadline. There is no deadline as far as I'm aware, but if you know of something, if you've seen something, then please send it to me. But I have not seen anything regarding a deadline. Okay. All right. And let's see, again, if you have any questions that I have not answered, you can post your question again. And sometimes some of the questions get mixed up because there's so many questions, and also for TikTok and Instagram, it's showing me when people joined. So that gets mixed in with the questions as well. So if I did not answer your question, you can go ahead and post it again in either English or Spanish, okay? All right, and Anna Lydia, I see your question, your other response here that he naturalized in the 80s and you're from Mexico. So yes, if he naturalized, then that would not help you in terms of passing on citizenship to you. Now, of course, I would have more questions. Did he ever file for you before in the past? Did your mother ever file for you before in the past? How did your mother get her residency? To see if somehow you were 245I, if you had a petition prior to April 30th, 2001. But just to give you an idea, as an adult child of a U.S. citizen from Mexico, immigration is working on petitions that were filed back in 1998. And when I say that, that means that, if your father had filed a petition for you all the way back in 1998, 22 years ago, it would finally be available now. Of course, there would be more complications because you would have been a minor at that time, and things are a little more complicated. But basically, for people that had started their case in this category back in 1998, they're finally eligible now to apply for their residency. And then as far as your mother filing for you, she would only be able to file for you if you're unmarried. So if you're not married in that category, immigration is working on cases from 1999. So if you were to schedule a consultation with us, we would be looking into those things, trying to, find out, did your parents ever file for you before? But then we would really need to look into your whole situation, see if we can find any good options for you outside of a petition from either of your parents because of how long those petitions would take. Right. And again, si alguien tiene algunas preguntas también en español, puede poner sus preguntas en español o en inglés, en cualquiera de los dos. Y también quiero explicar cómo funciona eso. Puedo contestar cualquier pregunta aquí en general. No puedo dar información específica como una opinión legal sobre su caso, porque para realmente dar una opinión legal tengo que saber mucho más información que realmente no puede darme en ese tipo de situación, que primero no es confidencial, pero el otro es que tarda mucho tiempo. En nuestras citas normalmente tarda entre 2 a 3 horas. Está separado en 2 citas, una cita con mi paralegal, donde ella hace muchas preguntas sobre todo su historial, y después una cita conmigo, donde yo reviso esas preguntas. Yo hago también más preguntas para clarificar ciertas cosas y puedo dar una opinión legal en su caso y en qué debe hacer. Pero en esa situación sí puedo contestar preguntas en generales, pero no puedo avisarle en exactamente qué debe hacer en su situación. Okay. All right, and Mariano, I see your question here. To clarify, does the time one spent as a conditional permanent resident count towards the 3 years, or does the 3-year period begin after one receives the condition been taken off? No, the time spent as a conditional permanent resident does count, because conditional permanent residents are permanent residents. So that does count towards the 3 years. So what happens sometimes, because of how long the I-751 petitions to remove conditions take, most people will become eligible to apply for their citizenship while they're waiting for their petition to remove conditions to be approved. And during that time period, once you get up to the 2 years, 9 months, you can, as long as you meet all the requirements, you can file for citizenship. Now, USCIS does have to approve that petition to remove conditions prior to granting the application for naturalization, but they can actually do both of them together at the same time. And sometimes filing the naturalization will push them to approve the removal of conditions faster and then adjudicate the naturalization application. All right, and Anna Lydia, can someone who lost their DACA because of a felony dismissed by the DA back in 2015, can they reapply now or try to renew? So I would need to know more information. If they were not actually convicted of the felony and immigration took away their DACA while the case was pending and then later it was dismissed, they could possibly try to reapply. I would really want to understand better factually exactly what happened in this criminal case, whether they were convicted and then later somehow it was reopened and dismissed. But they could possibly reapply. I will say technically DACA is discretionary. Even though they are only supposed to deny DACA for someone who has a conviction for a certain crime, I have seen times where they have revoked DACA because of a very serious arrest. So it really depends on their situation and it depends on immigration. I would want to know a lot more information about their case. Okay, so whoever this person is, I would recommend that they schedule a consultation and we can review their whole criminal history, review everything else in their immigration history, and see if they should try to apply again or not. Okay, Alma Fuentes. Hola, abogada, ¿cómo está? Tengo una pregunta. Si las personas que tienen DACA pueden pedir un permiso de salida. Sí. ahorita sí, puede pedir el permiso de viajar, pero tiene que, por personas que tienen DACA, para pedir el permiso para viajar, el advance parole, tiene que probar que tiene uno de tres cosas para calificar. Tiene que probar que tiene una razón de viajar por su educación, por la escuela, por su trabajo, porque tiene una razón humanitaria. So, en muchos casos, las razones humanitarias que personas usan para viajar con DACA es probando que tiene familia en su país, que quizás son viejos, que son enfermos y que quiere ir para visitarlos. So, por ejemplo, puede pedir el permiso para viajar, tratando de demostrar que quiere ir para visitar sus abuelos, si quiere verlos antes de algo pasó con ellos, que ellos son enfermos. Esos a veces sí son opciones. Ok, so si quiere hablar más sobre eso, puede llamarme. Ok, podemos hablar sobre eso. Ok, pero eso sí, sí es una opción. So, la decisión de este juez era que sí, inmigración tiene que aceptar nuevas aplicaciones de DACA, pero también si la programa de Advance Parole, de pedir el permiso de salida, eso está abierto de nuevo. So, personas que tienen DACA sí pueden aplicar para viajar. Y también la programa está como era antes, que están dando los permisos de trabajo por 2 años. Por un tiempo, inmigración dijo que solamente iban a dar los permisos de trabajo de DACA por 1 año, pero todos los permisos que ellos mandaron por 1 año automáticamente están extendidos a 2 años. Y también por los nuevos van a ser por 2 años y si puede ser las nuevas aplicaciones y eso. Por todos los que califiquen para DACA, mi recomendación es de aplicar. También por todos los que tienen DACA, debe pensar sobre si puede encontrar las razones de aplicar para viajar, porque muchos no entienden que si entró al país ilegal y si tiene DACA ahorita y si sale del país con el advance parole y regresa aquí, va a tener como una entrada legal o un parole aquí. Y eso puede dar mucho con ciertos tipos de casos con inmigración. Por ejemplo, si está casado con ciudadanos, si tiene hijos más de 21 años. Eso sí abre más oportunidades. Por lo menos como está la ley ahorita. Reciente inmigración sí hizo unos cambios en relación de eso por los programas de TPS. Inmigración dijo que por personas que están viajando ahorita, después de ellos hicieron esa decisión con TPS, que eso no va a contar como una entrada legal. Pero hasta ahorita inmigración no dijo nada sobre el programa de DACA. So, si tiene DACA, debe pensar sobre eso y debe consultar con un abogado si quiere ver si va a ayudar. Si hace eso, okay. And Anna Lydia says, regarding her question earlier, no conviction. It was a possession felony dismissed at court. But when his permit was expiring shortly after and had to renew it, he didn't send renewal because he was scared and never did it. But wants to try again now, has kept a clean record since. So if they never actually took it away and he just didn't file, then he likely could, but I do think it would be a good idea for him to consult with an attorney. And one of the reasons for that also is to look at how was the case dismissed. If and this is something very complicated with how immigration looks at whether something is a conviction or not, how they determine whether it's a conviction. So for example, if someone enters drug court, depending on how their local court handles drug courts, in some drug court programs, you have to actually enter a plea of guilty and say, yes, I was guilty of this. And then you have to do a process that's similar, very similar to probation, where sometimes you have to do drug testing, you have to go to hearings. And at the end of the case, they will dismiss the case. But unfortunately, what a lot of people don't realize is in these drug court programs where it requires a plea of guilty to enter into the drug court for immigration purposes, that is a conviction. even though at the end the case was dismissed. So I would really need to talk to them to confirm, was this really a conviction or not? And this is something that people need to be very, very careful with, because many people think, oh, well, if it's dismissed at the end, then that's all that matters. But no, it actually does matter what led up to that dismissal and whether there was actually a plea entered or not. Okay, Alma, sí, llámame mañana y si podemos hablar sobre eso. Thank you. So sí, personas tienen que tener mucho cuidado con eso de las convicciones, porque lo que estuve explicando, lo siento, estuve explicando eso en inglés, que cuando personas entran en un programa de corte de drogas, a veces un programa espacial similar al probatorio, y en el final la corte puede quitar los cargos. Por esos tipos de casos, si para entrar a ese programa, si la persona tiene que hacer una declaración de culpable, eso cuenta como una convicción. No importa si en el final, si los cargos fueron retirados. So, siempre cuando uno tiene un caso criminal y no tiene papeles, o si tiene la residencia, si tiene DACA, si tiene algo donde no eres ciudadano de los Estados Unidos, tiene que consultar con un abogado de inmigración antes de hacer nada con su caso. Okay. Si su abogado criminal dice o su defensor público dice que debe declarar culpable a eso, no preocupe, no va a afectar. No, siempre tiene que consultar con un abogado de inmigración. Yo he visto muchas situaciones donde personas hicieron cosas malas en sus casos criminales porque no entendió cómo funciona la ley de inmigración. Hay cosas también que residentes no pueden hacer. Por ejemplo, cualquier crimen en relación de drogas, por un residente, inmigración puede empezar un proceso de deportación. ¿Ok? Tiene que tener mucho cuidado. También con marihuana. Hay una excepción por menos de 30 gramos de marihuana por un residente, pero cómo funciona eso, esa excepción por deportación solamente cuenta si la persona queda aquí en los Estados Unidos por vida. Si una persona que es residente tiene una convicción de marihuana menos de 30 gramos, y si sale del país y reentra al país, inmigración puede ponerle en proceso de deportación. Persona tiene que tener muchísimo cuidado con cosas criminales. Y yo sé que marihuana está legal en muchos de los estados de los Estados Unidos, pero por inmigración no importa. No importa si está legal en donde vives. No puede hacer, ¿sí? Por inmigración, ¿sí? Eso puede meter en muchos problemas. So yo pienso que voy a terminar un poquito temprano hoy, pero siempre si tiene preguntas, puede verme en vivo y hacer sus preguntas en generales sobre inmigración. Pero si quiere una opinión legal sobre su caso, puede llamarnos para programar una consulta al 772-539-8400. 772-539-8400. So I think I'm going to end this early for today, but anytime you have any questions, you can always come to my lives and ask your general immigration questions, and I will try to answer as many of them as I can while I'm live. You can also send me a message on Facebook or Instagram. And if you want a personalized legal opinion about your case, then you can call me and schedule a consultation. Our phone number is 772-539-8400. All right. Thank you guys so much, and I will see you soon. Thank you. Hasta luego. Tenga buena noche.